Hi everyone. Apologize for the voice. I'm going to do the best that I can. I read about the case of Clark County School District versus Breeden that was taken to the Supreme Court of the United States in 2001. It first starts by talking about Title VII of the Civil Rights Act that talks about you can't discriminate against an employee because the employee has opposed any practice that made an unlawful employment practice by Title IX, or because the employee has made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under Title VII. So just keep that in mind, that they cannot be discriminated against because they put forth an investigation, started a suit. So the respondent filed a claim against Clark County School District. And what happened was that respondent was in a meeting with a male supervisor. So I'm assuming the respondent is female. It never gave me a name that I saw. So in my mind I was thinking Jill, but respondent was in a meeting with the male supervisor and another male employee, and they were going over the psychological evaluation reports of 4 job applicants. During the process, the supervisor read a comment from one of the files. The comment was for one of the job applicants. The comment said, "I hear that making love to you is like making love to the Grand Canyon," which then the male supervisor looked at the respondent and said, "I don't know what that means." And then the other male in the room said, "Oh, I'll tell you later," and they both men chuckled. So the respondent then proceeded to file, to talk to her assistant superintendent, Georgianne Rice, her supervisor, and to another superintendent, and just mentioned that those comments, just complained about the inappropriateness of them. And now she's claiming that there was retaliation against her because she made those assertions. The problem is that the court states that in order for it to violate Title VII, which is sexual harassment, that the action needs to be severe or pervasive. It means that it needs to actually make work so abusive in such an uncomfortable situation that work cannot continue, that the functions that you normally do cannot go forward. And in this case, the respondent even said in court that at the time she was not uncomfortable by the comments, that in those moments, they did not make her uncomfortable. So they said that there was not violating Title VII in any way, because she even admitted that it was not such a horrible situation, that her job status and the way she presented herself at work changed. They say specifically in here that you have to think about, does it unreasonably interfere with an employee's work performance? And she said no. And this is an isolated incident. Sexual harassment needs to be something that happens, is not just one isolated incident that has no connection to anything. It should be connected to multiple incidences. So they said this wasn't harassment. So when it went to the District Court of Appeals, or the District Court said, no, this doesn't violate Title VII. You have no grounds for seeking retaliation. Her comment was that because she then filed complaints, she filed harassment charges against them, she says that she was she had an unhappy transfer. So the assistant superintendent that she had complained to on April 10th made the comment to someone else that she was thinking about transferring the plaintiff to a different position. And I'm assuming it's an unpleasant transfer, because otherwise she wouldn't be complaining about it. The respondent had filed her lawsuit on April 1st, and Assistant Superintendent Rice made the comment on April 10th, but did not find out about the suit until April 11th. And so her comment came before she even knew. So therefore she could not be held as discriminating against, because she didn't know when she first started contemplating the transfer about the lawsuit. And so the court says that you don't have to change any of your planned transfers just because you are notified that someone has filed that Title VII has been violated. So you don't have to change previously planned things. And since she made this comment and was contemplating it before she found out on April 11th, therefore she was not held as discriminating. The Court of Appeals, when it was taken to, did reverse the district court's action. They said that the EEOC had, the Equal Employment Opportunity Commission had notified Rice 3 months prior to April 10th, when she made the comment, that the respondent was that the respondent had a right to sue, but that did not affect what Assistant Superintendent Rice knew about what was going to happen. She was just aware that that was there, but her transfer and the notice of the actual lawsuit didn't come until after the contemplation for the transfer. So pretty much the Supreme Court told the respondent, said, you have really shaky grounds here. You have nothing that's connected. You have to create some kind of connection between your discrimination and this transfer, and you can't really prove, you can't provide sufficient evidence that these things are connected. And so they reversed it and said, no, the district court was right. This does not violate Title VII because it was not harassment, that it was not sexual harassment as defined in the law, and therefore they could not discriminate against you because they also did not know about the lawsuit until after that had happened. And so it was reversed, and nothing else came about it.